Welcome, everyone. Thank you for joining today's webinar. My name is Stephanie Webster, and I'm the General Counsel of the IIB. We have a great webinar for you today on considerations for FBOs when receiving a cross-border civil, criminal, or regulatory request for information. I know that a number of IIB members have struggled with how to respond to such requests, and so we are very fortunate today to have three attorneys with extensive experience in this area. Jeff Alberts, a partner at Pryor Cashman and a friend to the IIB, is our moderator today. He is joined by Jennifer Heil, Head of Litigation, Human Resources, Government Investigations in the Americas Legal Department at MUFG, and Lee Renzen, Deputy Global Head, Global Investigations and Regulatory Enforcement at HSBC. Their bios are available in the links in the meeting invite sent to many of you, as well as on our resource page, a link to which was sent to all registered participants this morning. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them in the Q&A function at the bottom of your screen. For those of you on the phone, you may email questions to info@iib.org. Feel free to submit questions at any time during the presentation, and we encourage Q&A. If you would like CLE credit, Jeff will read a 4-digit code during the course of the presentation. You should use that code to complete the CLE attestation form and send the completed form to info@iib.org. Please also complete the evaluation survey, and links to the attestation, the evaluation survey, and all of the CLE materials, which there are a lot of, so a lot of helpful information there, can also be found in the meeting invite and on the resource page. So now, without further ado, I will turn it over to Jeff to get started.
Great, thanks, Stephanie. So I wish I could see you all today, but we're going to do our best to try to make this a conversational discussion of what you should do when you get a subpoena. And in fact, as I was working on this, I realized just how overwhelming it can be, how many different types of subpoenas there are and different types of issues that can come up. So there's a lot, but we have some experts on this to talk it through today, and hopefully it'll be kind of helpful. So we've tried to organize this around what you would do when you first get a subpoena, things that would go through your head. And to start out with, I just want to talk about the types of document requests that you can get. In fact, some are subpoenas, some aren't subpoenas. I'm not even going to talk about all of them because there are so many, but some of the major categories of subpoenas and document requests that you should be aware of include, for example, a grand jury subpoena. So a grand jury subpoena is a subpoena that generally is sent out by a federal prosecutor, and it is the beginning of a criminal investigation. It might be a criminal investigation into your bank, but usually it's just a criminal investigation into some wrongdoing by some other party, and your bank just happens to have some documents that relate to the investigation. Another type of document request that you might get from the government is a Patriot Act subpoena. So that's actually a different kind of subpoena. It can come from the Attorney General, but it also can come from the Treasury Department, and it generally relates to a BSA violation or other specific types of bank-related violations. However, there's recently been some changes in what can be captured by a Patriot Act subpoena, and we're going to discuss that in some more detail later because it changed at the beginning of this year. A third category of subpoena that you might get is a Civil Rule 45 subpoena. So those are subpoenas that aren't necessarily set out by the government, but they're sent out by any party who's part of a civil dispute. So it's not necessarily a criminal investigation, it's generally a civil investigation, and it can be a government entity that is in a civil dispute with somebody else, but it's often just some company or some person who sued someone and they think that your bank may have documents that relate to that type of request. A fourth category of subpoena that you can get that often specifically relates to documents that are located outside the United States that a bank might have is a Section 1782 order. And a lot of people don't even know these exist, but it should be in the back of your mind that it's something that you might receive. And that's an order where somebody is seeking documents using legal process in the United States to further a dispute that is outside the United States. So say there's some litigation going on in Spain, the two entities in Spain want to get documents using legal process in the United States, they can get a 1782 order, and that 1782 order can request documents that are also located outside the United States. So if the Spanish litigants want to get documents that are located in Brazil, they might come to the United States and get a 1782 order compelling the entity that's in the United States to reach out to Brazil, get the documents, give them to them, so they can then be used in Spain. So there's a lot of convoluted potentials for document requests. I've gone through some of the general categories, and you should know there's lots of other categories. So a number of different federal agencies have their own process and forms of document requests. You can get requests directly from the CFTC, from the SEC, from banking regulators, and they generally all have their specific format of request. And we haven't even got into state subpoenas or requests. So all of the 50 different states, they have their own district attorneys, attorney generals, and they often use either grand jury subpoenas or other form of legal process. So there's a number of different categories of document requests. The ability of people to use those document requests to get documents from banks, and in particular to get documents that are located outside the United States, varies greatly. But one of the first things that you should be thinking about when you get such a request is just figuring out which type of request is it. And there's a number of other things that you should probably think about as well. And Lee is going to explain those to you.
Yeah, thanks, Jeff. You know, if your heads are spinning after that because you're thinking, oh my God, right? Like, how am I going to keep track of all those? How do I know? And if you know, I think most, if not all of you, like me, work at global banks. So as lawyers, we spend a lot of our time trying to explain, you know, the intricacies of the U.S. legal system to non-lawyers and to non-lawyers outside of the U.S. So there's, you know, it could be really complicated and complicated, and subpoenas certainly are, you know, sort of a good, you know, or a common reason for or cause for confusion. So the first thing to do when you get one, and it seems kind of obvious, but it's important, is to read it, right? Because you know, as you could tell from Jeff's, you know, intro list, there are a lot of different kinds of subpoenas. There are a lot of different entities, public and private, that issue subpoenas. They could ask for all kinds of things, but really, it's all there in the subpoena, and so it's really worth taking a little bit of time to read through it. And frankly, probably, you know, if you're an institution like mine that gets a large number of them, to try to come up maybe in advance with some sort of like steps or processes. And I know sometimes processes sounds overwhelming, but even just like, you know, a checklist for how to triage these subpoenas. But all that turns on what the subpoena says. So subpoenas can look different. Sometimes they have fancy court seals, and you know, they're in fancy lettering. Sometimes they look like they came off your kid's computer. But so it's kind of hard to know. So you sit and you want to look, and what do you want to look for? You want to look for who sent the subpoena. Is it a government agency, or is it a civil plaintiff or civil party? Is it a federal law enforcement agency, or is it a regulator? The SEC could send a subpoena. The OCC could send an information request. There's all kinds of, so you want to look at the subpoena on its face, take a minute and see who's asking for information. You also want to see who they've sent the subpoena to. You know, the subpoena has to be issued to the right party in the right manner. And sometimes, you know, if you're complicated, financial institutions often have different structures in the US, and it's important to make sure that service was, that the subpoena was served on the right party. Look, at least in my experience, especially when it's a government subpoena, at the end of the day, you're going to work with the regulator or the government agency to make sure that they fix service if there's a problem, because cooperation, you know, 99 times out of 100 is the best way to go. But it's important. It's also important because you have, you know, if you weren't served properly, that could raise concerns if you turn over documents that maybe, absent a valid subpoena, that might cause problems. So that's important to see who it's sent to. You want to understand things like, what are they asking for? Are they asking for narrow categories like the bank records of a particular client or wire information for, a list of entities? Or are they asking for things that are much broader, like all documents related to A, B, C, and D, or all email communications regarding XYZ? So the scope of what's being asked for can really vary greatly. And these things are important because, one, obviously you want to know what they're asking for, but as I think we'll talk about in a little while, there's oftentimes a lot of room for back and forth with the requester to make sure that the scope is appropriate. And, you may want to try to narrow it. You may want to have a better understanding of what it is they're looking for. Because oftentimes when you send a subpoena, whether you're in the government or a civil litigant, you don't know exactly what the bank's going to have. So you're better off casting the net pretty broadly. But 9 times out of 10 don't want a massive, overproduction of records either. So there's a lot of room to work with the sender. So scope is important. You want to look for things like who's actually sending it. Typically, a subpoena will have the name of the attorney, might have the name of a law enforcement agent if law enforcement's involved, and those are the people who you would reach out to discuss those kinds of things. That's on the subpoena. It's important to understand if the request includes documents that are outside of the United States. That's something we'll spend more time talking about, but typically you could tell that from the face of the subpoena, and that's something you want to know. So as long as, I don't know if you guys have other thoughts, but bottom line, there's a lot of information on the face of the subpoena that'll really guide how you handle it going forward.
Yeah, I mean, one thing that pops into my mind regarding non-US documents is often you can't tell from the face of the subpoena whether they intend to include non-US documents. So they may serve the subpoena on a US entity and then just say all documents in your possession, custody, and control. And one thing to be thinking about there is that theoretically could apply to some documents that are outside the United States. Maybe there's certain categories of documents that the US entity has control over, and that possibility is something that it's worth thinking about and maybe quickly negotiating about, because it could be the person requesting didn't intend to include documents outside the United States, but they're not clear in their subpoena. And so you, through good negotiation, may be able to narrow that down very quickly just by clarifying what it is that they really want.
Yeah.
Right.
Oh, one thing I meant to add, and I didn't, and I know that's not really what we're talking about today, but from time to time, you might get a different kind of subpoena, a trial subpoena, where the party is actually seeking somebody, your institution, to show up in court and testify. I know we're not going to really get into that now, but lights should go off if you see that, because that's a different animal. But it's definitely something that
right.
See that.
One thing that makes that very different, for example, than grand jury subpoenas is grand jury subpoenas will have a date that you're supposed to show up in front of the grand jury, but almost never are you expected to show up in front of the grand jury. A trial subpoena, on the other hand, if you're subpoenaed to show up at a certain date and you don't show up, you may get a call from a judge saying, hey, I'm sitting here in court. There's a jury sitting here. There's a defendant sitting here. There's a court reporter. Where are you? And that's a bad moment for your bank. So definitely, as Lee said, trial subpoena should set off a different type of alarm bell and a different type of focus on deadlines and quick outreach than a grand jury subpoena.
Yeah, and just going back to something else that Lee said, it's almost what we end up seeing sometimes is the opposite, where, it's not that they did not mean to encompass documents that are outside of the United States. It's that they only want documents that are outside of the United States, but they sent it to our US entity. And for us, many times, that's where just the reading of the subpoena can actually be very important, because we do have authority to accept service on behalf of a decent number of affiliates of the bank, but we also are not authorized to accept service in the United States for affiliates that are solely outside of the United States. And so sometimes it goes to even the pure acceptance of the subpoena, whether or not we can accept it or not. And and we might tell them, hey, you sent us to some
I think
this
Jen,
thing with this entity on it, but we don't represent that entity. We can't accept service on behalf of that entity. And many times, Lee,
oh yeah, I can hear you. You were freezing up a little bit.
Oh, okay, I just want to make sure. Okay, can you hear me okay now?
Yeah.
Okay.
Oh, Jeff, I see there's a question popped up. Should we do that now, or do you want to, how should we handle the questions?
So this one is about the NDAA. Maybe we can postpone that answer until a little bit later when we're going to talk about some of the new rules around that. Does that make sense?
Yeah, that makes sense. We'll try to cover that in that discussion.
Definitely the hot button issue of the day in the world of subpoena.
That's right.
Definitely. So one thing that I also wanted to talk about with respect to when you first receive a subpoena is many times what we need to do at our bank is decide internally who or which group is going to handle the response to the subpoena. And I think this may be true in a number of different institutions, but we have a set group of people. It's actually for us called the Legal Process Department, and their main job is to handle routine subpoenas. So for example, subpoenas just asking about, bank account statements, many times for things like divorces, probate, that type of thing. If that's all a subpoena is asking for, usually we would actually send it along to that group, although keep some sort of oversight on it. If it is a more meaty subpoena, and frankly, some of the subpoenas that we're going to be talking about here are going to be these meaty subpoenas where there's going to be questions of law or a question of fact in terms of, okay, what is included, what is not, what are our potential responses to the subpoena. That's really where you have to make sure that you're deciding at the outset, okay, is it going to be someone in the legal department? For our group, it would be normally someone in the litigation group that would spearhead the response to the subpoena. Sometimes you may even want to go out to outside counsel. Jeff, I'm sure you get a number of calls a lot of the time from institutions that might need assistance, particularly if it is one of the more meaty requests for documents or data. So, but that's actually one of our very first questions. And then once we figure out, okay, who's going to spearhead it, then of course we have to sit down and decide, okay, who is affected here? Who can help us gather whatever it is in terms of a response to a subpoena? So if it is domestic, what business units might touch on this? Let's give them notice right away to make sure that they know that they need to preserve documents and help us collect documents. Is it going to be documents that are outside of the United States? If so, who do we need to connect with at home office or in a different branch globally, to make sure that we're collecting everything that we need to. Of course, there are some issues which we'll talk about a little bit later on in terms of, okay, is the reach of the subpoena wide enough so that we actually do have to bring in home office or anything outside of the United States? But I think a core thing sort of going along with what Lee was discussing in terms of reading the subpoena at the very outset, you're going to be much better organized in terms of responding to a subpoena if you sit down and decide, okay, who inside the bank is going to be responsible for responding to the subpoena, and also who are all the groups that are going to be affected and who are we going to work with, and how are we going to dole out the responsibility for collecting things and funneling them so that we can send them out for the response. So, and I think that we're going to then talk about, Lee, I think you were going to kind of cover a little bit, okay, once we have a sense of, okay, what does the subpoena seem like it's covering, which a lot of times I think sometimes people send subpoenas with certain words in it, but they don't realize maybe they're way too broad or even way too narrow or something like that. I think Lee, you're going to talk a little bit about like how then do we approach the person who sent the subpoena?
Yeah, and I saw another question pop up, which maybe I can cover, which says if the U.S. entity is not authorized to receive the subpoena on behalf of the non-U.S. affiliate, do you refuse or do you cooperate? As an initial point, I think it's a good question, and that could be one of the things that you talk about when you pick up the phone. But I think the short answer is, I don't know, Jeff, what advice you'd give typically, but depending on who's sending it, there may, it may be in the bank's, your client's interest to try to cooperate, but sometimes if it's not in your interest, if it's a civil suit or something, you may just, just say not. But there are options, and I think it's worth. But I guess one thing you don't want to do is just, if you don't have a validly served subpoena, you don't want to just produce documents, because that could really expose, your institution to some risk.
Yeah, and actually, for a long time, our bank would get civil subpoenas, really only looking for. Many times there are people who have judgments in the United States against foreign entities, many times for injuries sustained by terrorist attacks or something like that, and they're trying to get to money in order to be able to, fulfill those judgments. And so many times they're just going around to a lot of different banks looking to say, okay, hey, do any of these entities have accounts at your bank? And but many times we certainly, especially if these are entities that are on the sanctions list, we don't have those accounts in the United States. They might be in a foreign branch or in a home office or something like that. And if they didn't serve the subpoena on the right entity, we actually had a letter, just like a sort of form letter that we would send back saying, we've received this. We don't have the authority to accept this subpoena. It does seem as though that's the entity that you want to get to. We can't respond. Give us a call if you want to discuss it, but we can't respond. And so we to answer the question, we do not accept service, and we're clear right from the outset that we're not accepting service, so we can't be said to have sat on it for too long or something like that. So.
Yep. I mean, we have similar. So now, sorry, I took us off track, but in terms of dialogue with whoever it is that sent you the subpoena, that's typically their phone number, and maybe I'll focus for a bit on a subpoena from a regulator or a law enforcement agency or prosecutor. They will have the name of a lawyer, the prosecutor. They will have the name and number, typically, of an agent, law enforcement agent. And you can go pick up the phone and call them, and oftentimes that's what they want. Jeff and I, when we were prosecutors, we used to send them all the time, and we would get calls, and it's totally normal to pick up the phone and say, "Hi, I just got the subpoena." If it's a prosecutor or another sort of high priority sender, you might want to say to them, "Look, I can be your point of contact going forward. I'm here. I want to help you, but I want to understand what it is you're really looking for." It may be that, like, if the subpoena is clear on its face, you may not need to. But if you have questions, if you are thinking about whether it might be advantageous to try to scope it, maybe they have a list of 100 subjects in the subpoena, and that could take you ages. And maybe you could say, "Look, is there a way to prioritize?" They may have 10 categories of documents, ranging from relatively easy things like maybe wire records are easy, whereas KYC information or another thing we get that's complicated sometimes are things like the HR file for an employee. Well, like in this day and age, who has a single manila folder? That's the file. I mean, those are so, you can pick up the phone and say, "Okay, what do you need first, or what do you really need, or if I get you this, would that work?" And so you can learn a lot and sort of develop a rapport, which could be helpful. You can negotiate the timing. The subpoena, it may be a short. You may look at it and say, "Oh my God, this is due in 2 weeks. There's no way I can get it done." You can call up and have that kind of a discussion. Importantly, and this is something I think a lot of folks know, but sometimes don't, if it's not something that you encounter a lot. If you have a subpoena from a law enforcement agency or a regulator, and especially the DOJ, because they're more sort of familiar with this question, you can ask, "Hey, are we the subject of this investigation that you're conducting, or are we just the third party who might have records?" Typically, the DOJ will tell you, and that is obviously really important, because if you're told that you are a subject of the investigation, that will change a lot, and almost certainly will lead to a call to external counsel, because now you know that this is a more significant risk to the. Sometimes some prosecutors maybe don't tell you that. The farther concentric circles away from the DOJ you go, sometimes folks aren't as prepared for those questions or don't give you as much information. But it's certainly worth asking. So you can do that. You can do that yourself. You can, that may be something, if you don't, routinely have discussions with regulators, that might be a good, reason to call somebody like Jeff and say, hey, can you just, make a call and help me understand? And I think, Jeff, I'll let you answer, but I assume that you get those calls a lot, and that doesn't necessarily mean from your mind that, oh, the bank's going to retain you to handle this whole subpoena. You might just, be able to help out and take it from there.
Yeah, absolutely. I get one-off calls all the time, particularly if it's somebody who is responding to a subpoena from a U.S. Attorney's office where I used to work, and just they want to get a sense of, can I ask this question? Can I ask that question? And I'm happy to respond to those type of questions. And it often doesn't build into any type of full litigation or engagement or a lot of work. It's just helpful for people, and I'm happy to help out with that. One other thing that I would just point out, after you have this type of initial dialogue with prosecutors or other federal agencies that sent out requests for documents, it's often helpful to just send them some type of documentation confirming the nature of your conversation. So if you have a conversation with them and your perception is they're agreeing to modify the deadline or narrow the scope of discovery, it's useful to at least just send them an email or a letter that just says, thanks for speaking to me. I appreciated the conversation, and my understanding is that you've modified the subpoena in the following ways, and just lay it out. Because especially if you're dealing with like a state agency that handles hundreds of cases, they won't necessarily remember exactly what they said on the phone to you, and they may later say, hey, I don't remember narrowing the subpoena, send me all those documents. So it's just useful to establish it in writing right away.
Yep. And I was going to say, when it comes time to produce down the road, again, you want to sort of lay out in the cover letter, if, as discussed, we're producing A, B, and C, or any sort of, important, or frankly, any narrowing of the scope would be good to reflect in the production letter as well. Yeah. So I don't know if you guys have any other thoughts on what to things you might want to raise on a call. I guess I would say, like, it's good to go into, if you are going to call, it's generally, I would say, go into those calls with the mindset of, let me see how much I can learn, as opposed to how much I can share, because you really don't know where the subpoena is coming from in terms of like the intent behind it. So it's really good to just sort of be in listening mode, and you can always, if they ask you questions, say, I'll get back to you on that.
Right. Yeah, I mean, one thing that I guess that's a natural transition to what I was going to talk about next, which is how best to assess the urgency of the request. So one of the first things that should be a red flag is if they are treating you as if you're a subject, whether they actually say that you're a subject or they have kind of a hostile attitude towards the questions that you're asking. That may lead you to think, oh, it looks like this could be an investigation into us, and that would make it a lot more urgent. You would want to right away be reaching out to outside counsel, notifying people that are higher up within your organization about the nature of the inquiry. So that focuses on whether they're a subject or a target. Another issue is whether it's civil or criminal. So when you get a subpoena, you want to right away figure out, is this a government agency? And then if it's a government agency, is it criminal versus civil? Often civil inquiries are less high priority. It can be different if it's your prudential regulator, that can be relatively high priority. But if it's just somebody making a routine investigation from another federal agency, that would be different than if it's a, say somebody in the Department of Justice within their bank integrity unit sending out a subpoena inquiring about your BSA policies. That might sound, the language of that might sound very neutral, but it might in fact be very urgent because penalties that are imposed on banks for BSA violations tend to be very significant. On the other hand, you may get an inquiry into something that sounds like the language sounds very urgent because it's talking about like a drug transaction or a murder, something like that. But often those aren't, as urgent for your institution. You want to respond quickly to assist with the investigation, but they may just be treating the bank as a custodian of records and trying to get records on a routine basis. And your bank doesn't itself need to worry about potentially being the target of that investigation. Another thing that you want to focus on relatively quickly is whether or not the inquiry appears to be systemic in nature or about a specific transaction. So often inquiries that look like they're laying the foundation for an investigation into the entire bank's bank BSA AML policy, that's more urgent than if it looks like it's just trying to trace one specific transaction. Because in that case, the bank is more likely to not even be the target. And even if it is the target, it's more likely to be discrete than if it is focused on the bank's entire policy and mode of operation, which can suggest that there may be a much larger potential fine coming down the line. So while I'm on this, I am going to now read the code. In order to get CLE credit, you have to note this code. You should all write it down now. It is 6308. That's the code. So write it down. I think when you apply for CLE credit on the line, there's a little line that you have to write it in. So again, 6308. So after urgency is assessed, that can inform the next decision, which is whether to involve outside counsel. And I think, Lee, you had some comments on that.
Yeah, and actually, if I could jump in quick before Lee. So one interesting thing about what you said, Jeff, is with systemic and focus, another aspect also in terms of systemic, it can actually be not just looking at your bank as a whole, but looking at all banks. And I'm sure that's actually something where outside counsel can come in handy is, oh my gosh, we just got the subpoena asking for all this stuff. And then we call you, Jeff, and you say, oh, you're actually one of 40 different banks that received the same subpoena because they're looking into whatever it is. And to me, that knowledge can actually be really helpful because it's like, okay, obviously we still have to respond to the subpoena as best we can, but it at least gives us the information of, okay, we're not likely the target. They're just looking at the market as a whole. So that's the type of information that can also be really helpful. That outside counsel, I think, that's one of the things where you might have your ear to the ground and kind of know what's going on across the market. So Lee, I think you had
a sure. Although I did see one question, I might as well. When do you discuss GDPR issues with DOJ or SEC? I'll pick that up because it sort of goes back to what we were talking about earlier about things you can discuss when you have that call. I mean, I don't think there's any right answer. You can discuss it whenever it makes sense to. One thing I would really caution folks about is that by this point, certainly the main players in the subpoena sending industry, like DOJ and regulators, are quite familiar and have a pretty good handle on GDPR, on data privacy and bank secrecy laws from sort of frequent the familiar non-US jurisdictions. So I think a general, oh sorry, we can't produce, our home country won't let us, will be met with I don't want to say skepticism, but certainly is you should anticipate that they will be prepared and they will have a good understanding of what the local laws are. And so, there may be that may lead to sort of a back and forth discussion. So, and frankly, I think, you can even, if you look across corporate resolutions with regulators, you will see that oftentimes, you know, the banks or the company's willingness or unwillingness to produce documents from foreign jurisdictions is something that, you know, is featured in the cooperation sections. Long story short, I would just sort of, it's always fine to bring up. It's always probably good to bring up sooner than later, but I would do it in a sort of thoughtful manner, in the sense that, like, be prepared to defend or back up whatever position it is that you're going to take. And it could be as simple, you know, and frankly, you know, an initial conversation could be as simple as, you know, look, you know, your request may require us to work through some tricky issues. So we will do that, but it may take us longer than it might otherwise because of that reason. And that's, you know, you will assuredly not be the first subpoena recipient to start that dialogue. So probably better to do it sooner than later.
Yeah. My experience with that, somewhat unfortunately, is that we get very, very little sympathy from U.S. authorities. You know, if it's a civil case, obviously that's a different story. But with respect to authorities, you know, they'll say, okay, well, that's nice, but I think the expectation is you find a loophole or you find an exception to fall under or whatever it is, and obviously it does create a lot of internal work because you know, our home office is Japan. They do have, it's not quite as stringent as GDPR, but they do have a fairly stringent data privacy rule, and we're always being asked for documents from there. And there are various, as I said, I don't want to call them loopholes, but there's various exceptions that you can kind of look to under the Japanese data privacy law. But we have to work our way through it. Many times we have to hire outside counsel in Japan to review it for us, and it does take time. And so, but I think it does help if at the beginning we say, okay, we want to work with you, we want to get you what you want, but we also have to make sure that we're following the law in the countries where this information is located. So, but Lee, I think you had a couple other items you want to know.
Oh yeah, sure. Involving outside counsel, and when do you do that? I guess there's sort of two. There's the, you know, do you want to involve them at the outset just to sort of have that initial dialogue with the regulator or whomever is serving the subpoena to sort of help you assess? That really, I think, depends on, you know, your comfort level with having those conversations yourself. In terms of retaining outside counsel to handle the subpoena, I think a couple factors. I think if you learn that you are the subject of the investigation or a concern that you might be, that's certainly, you know, a good time to get outside counsel. I think even if if you're not, but, you know, sometimes subpoenas are unwieldy, and depending on you know, the scope of the subpoena and what your own internal resources are, you may need the help. You know, the subpoena may require reviewing documents for privilege. It may require, you know, making relevance calls just on a sort of large scale, and you just may not have the resources or the support to do that. So that may be another reason. You know, obviously costs weigh in here as well. So that's something everyone has to balance. I would be surprised. I don't think that sometimes people ask, well, if we get a lawyer, an external lawyer, is that going to, you know, send a message, whether it's send a message to a regulator that you're nervous or send a message to a civil, you know, I think I never put too much stock in that. I think, you know, these are all lawyers all around. So I don't think people typically are surprised when an external firm shows up on the other side. I don't know, Jeff, if that's your experience, but I don't think.
Yeah, that's definitely my experience. And, you know, as you know, Lee, when we were federal prosecutors, we would deal with banks all the time. And when we got a call from outside counsel, it was not surprising. We know that banks have lawyers.
Yeah.
And often it was great. Like it was often much easier to work with people that kind of were familiar with how the system works, and you could more quickly get a reasonable outcome. And it would be both in the interest of law enforcement and in the interest of the bank, because it's very difficult to negotiate if you don't understand the playing field. And so I find that frequently banks bring me in if they don't have internal resources that are just familiar with what's reasonable to ask for and what's not reasonable to ask for. And that makes it very difficult to establish a dialogue and narrow the scope of the request quickly. Whereas a former prosecutor both knows the scope and can say things like, you know, I used to make the same kind of request. Is there any way we can do this or that? Or I know that, you know, this is more than you're typically asking for. You know, is there any way that we could modify it to be more consistent with what you normally do? And if you don't know what's normal, you just can't negotiate that way. And that can end up costing a lot more down the line, because if you don't narrow the subpoena, you then can spend massive amounts of resources responding to the subpoena. And you could have avoided all that if you brought somebody in to just do the negotiation. You know, you could be talking about a half-hour call, and that saves your institution hundreds of hours of wasted time trying to collect documents that they otherwise wouldn't have had to collect at all.
Right.
Yeah,
The flip side is, oh, I'm sorry, go ahead.
I was just going to say that that actually happens with us quite a bit, because you know, we work fairly closely with internal counsel from some of our affiliates, but they, you know, many times they don't have, you know, folks with litigation, you know, investigation type of experience in-house. They just have sort of jack of all trades type of attorneys. And so they'll get a subpoena many times and say, oh my gosh, they're asking for this, this, and this. And then they'll be off to the races, starting to gather stuff internally. And then they'll come up with a question and they'll say, you know what, let me call, you know, the litigation group. And when they call us, we're like, please tell me that you did not do anything yet on the subpoena, because there's, you know, like you can either negotiate this or whatever it is. And they're like, oh my gosh, I already spent like, you know, an entire week gathering documents. We're like, well, you didn't have to do that, you know, and sometimes that's outside counsel that does that, but sometimes it's just, you know, someone who has, you know, that much more familiarity. So, and then also just in terms of, you know, calling outside counsel, I don't think that there's any, you know, sort of bad thing about having outside counsel respond, because for us, many times we are so lean. And so while we try and handle some of the, you know, some of these subpoenas as much as we can internally without having to call outside counsel, sometimes we just don't have the resources. And so we have to, you know, we have to call outside counsel. So I don't think, I would hope that there's not an assumption that, oh, just because you hire outside counsel is, you know, you're nervous about it or, you know, something like that.
But the flip side, I should just say, you know, we do, you know, as a big bank, we handle like the vast majority of subpoenas, you know, internally. And, you know, certainly there's no, especially for the run of the mill ones, you know, even with the regulator, if you have comfort that you're not, you know, the subject, there's certainly no reason not to do it on your own if, you know, that seems better for your institution.
Yeah. So I think one of the things we also want to talk to is we're really trying to walk through, okay, what are the initial steps and what are the things that you really need to make sure that you think about when you receive some of these subpoenas is document preservation notices. You know, sometimes, you know, as we were discussing, these things are so routine that it doesn't really, you know, and of course, this is a call that you have to make, you know, internally. But sometimes, you know, as mentioned before, if the subpoena is just asking for, you know, U.S. domestic, hey, we need, you know, 6 months or a year's worth of account statements, you know, you pull those, you send them out, it's not an issue. But if it's a much more complicated subpoena, it is something where everyone should consider sending out a legal hold or, you know, document preservation type of notice. And, you know, you kind of basically do the same thing as you would if you, you know, at the beginning of a lawsuit, and when you first receive notice in a lawsuit. You know, so the same idea of, okay, who has documents or has knowledge of documents or data, who are the custodians, and then whoever they are, you know, make sure that they receive notice sooner rather than later that they need to be preserving. One thing I was going to mention, especially because of the international nature of our business, and sometimes, you know, as we're discussing, sometimes there's documents outside the United States that end up being relevant, or at least might be relevant, and we'll decide whether or not we need to pull them and send them, is, okay, well, how do you send a legal hold notice outside of the US? What we've done at our bank is we have what we call sort of our international legal hold workflow, which is that our global legal groups are divided into basically 4 regions. We've got Americas, EMEA, Asia, and then Japan. And so the kind of agreement that we have among everyone is that, okay, if you have identified a custodian in a region other than your own, you draft up the legal hold, and then you send it to the legal group, the internal legal group in that region, and then they are responsible for sending it out, and maintaining, okay, here's a list of everyone who has received it, et cetera, et cetera. And it actually works quite well. And really our main reason is that I think it's kind of scary to for someone who's sitting outside the United States, particularly in a region that is not as familiar with US style litigation and investigations, to all of a sudden get something from a US lawyer that says, you must hold all documents and do not delete anything. And it's just like, what, so what we usually do is we put that task up to people who are in their region, who they might feel more comfortable picking up the phone and saying, okay, what is this? What do we need to do? And that type of thing. But it's something that I think we all do kind of routinely, as I said, if we were to receive a lawsuit or something like that. But I think in the subpoena context, we also need to think about it as well. So, just another thing to kind of keep in mind. I know, I think we're going to talk about narrowing search parameters. Jeff, did you want to kind of touch on that at this point?
I'm just mindful, guys, in terms of timing. I see there are a few questions. Should we try to hit some of those, or how do you guys
so I'm going to try to cover some of a lot of them seem to relate to the jurisdictional limitations in the NDAA. So I'm going to try to cover them towards the end, although we're going to be going at a fast clip given the amount of time left. So keeping that in mind, I'll just very quickly cover a few issues that relate to narrowing search parameters. The first point that I want to make is it's important when you're negotiating with the entity that sent a request to you to first have a sense of what the potential collections of documents are. So one example of that is what we referenced before. You should remember, this could involve documents that are in the United States and outside the United States. Maybe I can narrow it to just one of those two categories. Similarly, you want to be able to you want to quickly know, are the documents that are responsive just emails, or might it also involve like huge databases that are proprietary and very difficult to extract information from them? Because often there will be things that will be kind of responsive to the request, but the requester really didn't intend to include, that would be incredibly difficult for a bank to collect. Emails are often easier to collect, but other forms of communications, even communications that some financial institutions use like email, but that are slightly different. So they may have chat functions that they use. They may have certain forms of communication that employees use on their personal devices, but the devices are also partially work devices, and that can create difficult line drawing issues. So it can be very useful if you first figure out what the potential categories of documents are, and then on the call, try to quickly cut off those categories that would be the most burdensome to produce. And often that'll be completely fine with the other side. They may only have had in mind emails and won't have thought about these other forms of documentation that are very difficult to produce and that they really didn't want anyway. In addition to that, you should be thinking about narrowing custodians. You want to quickly think about narrowing time periods. Once you may know more about the issue than they do, and so they may ask for a 10-year period. You know that the activity that they're referencing only occurred during a 3-year period, and so it may, in some instances, make sense to say that to them in order to get them to agree to narrow the time period. And another thing that you should keep in mind, which Lee referenced earlier, is the notion of kind of temporarily limiting the scope. So you may say, you asked for these 10 categories of things. What we'd like to do is first produce categories 1 and 2, then you can decide whether you need the other 8. Or we're going to produce 1 and 2, and for now we won't produce the other 8. You can re-request them if you ever decide that you need them. And sometimes they'll agree to that because they really will have a certain priority of what they want. And you'll get the benefit of getting to postpone or in fact never do the other categories of collection for more distant time periods or more difficult to capture documents. So we've gone through a lot of different things that you should be thinking about. There could be a lot of potential minds that are uncovered when you're talking to the other side and they don't agree to what you want or they treat you hostilely. And sometimes you've got to go up the chain and tell important people that bad things are about to happen. So I will let someone else talk about that. Jen, do you have any comments on that topic?
Yeah, and I'm going to go through this just very, very quickly because I think everyone is sort of really can't wait until the next couple of topics that we have, and I want to make sure that we have enough of time. But I can't stress enough, though, Jeff, what you suggested, which is that if something really starts heating up, you know, the escalation and making sure that senior members inside the bank, you know, are told what is going on. And, you know, I think everyone sort of knows, okay, this is what I need to do in terms of reporting inside my own institution. But I think that, you know, likely, you know, some quick, you know, rules in terms of, okay, this is when you want to be, you know, running things up the chain to executive or management committee level, running it up to board level is really when you, the first, when you, if you hear that the subpoena is really targeting the bank, and it is, especially if it's one of these, as you said, like a systemic thing, but even if it's a more targeted subpoena, you really want to tell folks early and often just to make sure that everyone is aware, particularly if it looks as though there might be any responsibility or any sense that anyone at that level might be a witness. And so, and of course, you'd want to inform your outside counsel of that as well. So, you know, different places have different ways of informing board members and executive committee members. There might be, okay, you might want to wait until a formal meeting and then, you know, give an oral update, or it may be so urgent that you might want to just, you know, have a phone call or even send an email to give notice. And I think that's where some of the things that we've been talking about already, you know, assessing the urgency, assessing, you know, what's really covered by this type of thing, that's going to help you make your decision on, okay, you know, when and how, you know, how kind of urgent am I going to go to the board? Am I go to the executive committee to let them know about this? But it's something that, you know, like, I think it can happen sometimes where, you know, a lawyer gets something, oh my gosh, we have to work on this, whatever. And then you're forgetting, okay, I need to tell the folks that, you know, we report up to, because they might get a question, you know, like one of our prudential regulators may have heard that we received a subpoena, and they might say, oh, hey, you know, we heard that you got a subpoena. And if they say what subpoena, then it's really, you know, it's not going to be great for your institution. So just something to keep in mind.
Right. I mean, I think, you know, maybe a good rule of thumb, I'm sure we all have experiences where, you know, the bank or the institution finds itself in a, you know, in a less than ideal situation, whether it's because it's the subject of an investigation or simply because it's just, you know, embroiled in something. And, you know, the question is, well, you know, when do we first know about this? And a lot of times the answer is going to be, oh, remember that subpoena we got a year ago or 2 years ago or something like that. Now, look, hindsight's 2020, and sometimes, you know, there's no way to know when you get a subpoena, for example, with a couple names that don't mean anything to you, what that will lead to. One thing I would, you know, suggest, it's you know, it's easier said than done sometimes, but to the extent that, you know, it's always a good practice to try to, the best you can, track subpoenas, look for trends, look for, you know, they really use them as an indication to the extent you can of, you know, potential red flags down the road. You know, regulators may ask, you know, let's say you're an institution and the government is investigating, you know, a large money laundering ring, or, you know, overseas tax issue, or bribery issue, or whatever. I mean, you know, you pick the hot topic. You may have gotten a few subpoenas where if you put the pieces together sooner, you might have realized, hey, wait a minute, we might have some issues in the bank. Maybe we need to do some checks. Maybe we need to see if we ran, you know, the KYC right on these folks that the government seems to be interested in. Those kinds of things, because, you know, investigations go on for a long time, and to the extent you can, it's good to avoid or to be able to say to a regulator, whether it's your prudential regulators or you know, a government investigator, to say, yeah, you know, when we started seeing this pattern of subpoenas come in, you know, we kicked our our compliance procedures into play. And so subpoenas can be a good sort of early warning sign of issues. And I think more and more regulators, expect that and will ask what you did, in response.
Yeah, I think that's an excellent point. So I think a lot of the questions, Jeff, as you said, really relate to the, jurisdictional limits and arguments that we might be able to make when we receive these type of subpoenas. So Jeff, did you want to go over that? And I know we're going to have time to answer every single specific question, but maybe if we can give some general kind of overview in terms of what to look out for.
Yeah, so there's a few things I would say initially. One is that along with your materials, there's a PowerPoint as well as very extensive materials that relate to this issue. So that's something that you have an opportunity to review after this presentation. You can circle back if you have any questions. The second is, because some of the questions are very pointed, I should just make the point that I can't give legal advice over this. So any comments that I make are just my views, not those of the law firm. The same is true for Lee and Jen. We're all participating, giving our views as part of this CLE, but we're not making representations or giving legal advice on behalf of the companies that we work for. With respect to jurisdictional limits, the starting point is the US Constitution. So it's very general, but the reason I make that point is because this area of law is actually very unsettled right now. It just changed. The NDAA was passed, which I'm going to briefly discuss, but it was just passed at the beginning of this year. And it may change the way not just subpoenas that are issued under the NDAA work, but it may affect how courts view jurisdiction in other areas as well. But the starting principles are just, what are the contacts between the financial institution and the United States? They'll evaluate that both with respect to the Home Office and through the Home Office if there are subsidiaries or affiliates within the United States. And they evaluate that in two ways. One is they evaluate generally the contacts between the bank. And then the second is they evaluate the contacts between the foreign bank and the specific issue that is being investigated in the subpoena. So if the bank is just the custodian, they tend to focus on the general contacts of that bank outside the United States to the United States. And if the bank is actually the target or the subject of the investigation, they'll focus more on the contacts between the foreign bank and the United States with respect to those specific transactions. And that is in order to comply with notions of fair play and substantial justice, because banks that are outside the United States and have no contact with the United States, they shouldn't be hauled into a US court and forced to produce lots of documents if they never had any contacts whatsoever with the US. So I'm going to talk very quickly about some specific categories. One is grand jury subpoenas. And the main point that I wanted to make with respect to grand jury subpoenas is that without knowing it, you may have already consented to jurisdiction in matters that fall under general US banking law when it is identified in a grand jury subpoena. And that's because when a foreign bank applies to do business in the United States, when it opens up a branch, in that branch application, it will often actually consent to jurisdiction. So that's one of the first things that you should check for. And in addition, you should know that it is not necessarily a defense, and this applies both to grand jury subpoenas and to Patriot Act subpoenas, that producing the documents would be unlawful in the country where your home office is located. So a lot of banks that are located in the United States, they'll reach out to Home Office. Home Office will say, it would be illegal for us to produce those documents. And there's a specific case called in re sealed case, which is mentioned in the materials that we circulated today, where two Chinese banks argued, well, we can't produce those documents that are requested in a grand jury subpoena because it would actually be illegal in China. And the court said, no, you still are required to produce them. And because you didn't, we're going to impose a financial penalty on you. So you should just keep in mind that's not necessarily an absolute defense.
Sorry to jump in, I just want to underscore that, Lo, not necessarily is the key phrase, right? The facts there were pretty, pointed for the government. I mean, it was an investigation of North Korean nuclear procurement, I think. So I think the long story short is what Jeff's saying. The point is the standards, it's a multi-factor test and there's room for courts to go different ways. So it's not an automatic, oh, turn everything over because we can't rely on a, home jurisdiction protection. It's multiple.
And the same thing is relevant to the changes that were just made under the NDAA. So it was expanded in January 2021. It expanded the ability of the Attorney General and the Treasury Department to seek documents using Patriot Act subpoenas, and it was a huge expansion. I mean, now the Attorney General, the Department of Justice, Treasury, FinCEN, they can use these subpoenas to get any documents that relate to criminal violations, Bank Secrecy Act violations, civil forfeiture actions, or what are called 5318A investigations, as long as the bank has a correspondent account in the United States. And the law is very expansive, but we don't know, A, how aggressive the government's going to be in using those subpoenas, and B, we don't know, and this is a response to a specific question that was asked today, we don't know whether or not the law will be successful when it's challenged. It may well be unconstitutional in part because it seems to be requiring broader production than courts have been historically providing in terms of what a bank has to produce regarding documents that don't even relate to the correspondent account in the United States, because it seems to authorize the government to demand documents from the foreign bank that don't even relate to the correspondent bank account in the United States. And that would exceed what most courts have suggested in the past. So there's going to be litigation over this. It's relatively complicated. It's changing right now. And even changes that occur within the Patriot Act are likely to impact other subpoenas and how the court evaluates what types of contacts between the foreign bank and the jurisdictions in the United States are necessary to comply with the US Constitution. So I hope that was helpful. I think we're out of time. We could definitely spend an entire hour just talking about the NDAA and all the possible permutations. But the important thing to keep in mind is it is a fact-specific inquiry, and it's going to vary from bank to bank. It's not something where you can just quickly check the box and say, all banks that are branches will be treated in way A. All banks that are subsidiaries will be treated in way B. It's going to be different from bank to bank, depending on the specific subpoena and the specific nature of the contacts between the foreign bank and the US subsidiary or branch.
Jeff, Jennifer, Lee, thank you very much. This was incredibly informative and very practical. So we very much appreciate you joining us. For those of you who want CLE, please complete the form, send it to info@iib.org. Don't forget the code. What was it, Jeff?
6308.
And again, thank you all for joining us.
Thank you so much.
Thanks.
Thanks, guys.